Good morning, chums, and welcome. Thank you for making the time to join our community today. We are tracking a story that has been whispered among palace watchers and constitutional experts, a story that frankly strains credulity. It centers on the Duchess of Sussex, Meghan Markle, and an astonishing claim that she is actively preparing for a legal fight against the British royal family to preserve her title. We are talking about the possibility of a court case against the Crown, led by the future King, Prince William. As ever, let's break down the claims and the cold, hard legal reality. An asset, not a birthright. To the Sussexes, the Duke and Duchess of Sussex titles are not just honorifics, they are the foundation of their entire commercial brand. They are the single, most valuable asset left after their departure from royal duties. Yet, this alleged willingness to sue to keep the title directly contradicts her own public narrative. Recall the 2021 Oprah interview, where she famously suggested that titles meant nothing to her. But since then, we have seen the opposite, a near-obsessive attachment to her status. Sources have confirmed the private use of her royal cipher and the inclusion of the HRA, Her Royal Highness style, on private gift cards, actions that, while technically not illegal since the style was retained but agreed not to be used publicly, demonstrate a clear intent to cling to the highest possible royal association. This blurring of the private use of a royal style for public, though non-commercial, effect is what has reportedly infuriated Prince William. It signals a reluctance to fully divorce their brand from the prestige they once claimed to disdain. The Andrew and Fergie precedent now. Why would Meghan Markle believe she needs to resort to legal planning now? The answer lies in the chilling precedent set by King Charles III's recent actions. The removal of the Prince title and HRH style from his brother Prince Andrew following a formal letters patent has sent a clear message. The Crown is willing to use its constitutional power to slim down the monarchy and protect its reputation. Sources say that Meghan was even more spooked by the situation involving Sarah Ferguson, the Duchess of York. Like Meghan, Ferguson was a commoner who married into the core royal family. The eventual, albeit complicated, loss of her direct royal status after her divorce, and the continuous public debate around her attempts to monetize her connection to the title, is seen by Meghan as a roadmap for her own vulnerability. The feeling is, if the king will make these painful, unprecedented moves against his own brother and former sister-in-law, what protections are really left for a non-working member living across the ocean? The legal delusion versus constitutional authority. This brings us to the alleged legal strategy. The claim is that Meghan believes her sustained, highly publicized use of the title Duchess of Sussex, which she has even referred to as a Bing family name, grants her a legal basis to fight its removal. This is where the alleged advice to the Sussexes becomes highly suspect. The HRH style. The simplest part is the HRH style. As constitutional experts have noted, this is an honorific, not a title of peerage. It is granted by the monarch's royal prerogative via letters, patent, and can, essentially, be removed just as easily, likely without any recourse for judicial review. The dukedom Duchess of Sussex. This is the more complex part. A dukedom is a peerage, and its removal is not a simple matter. Historically, peerages are removed through the Titles Deprivation Act of 1917, used against wartime enemies, or by an Act of Parliament. While King Charles may use his royal prerogative to remove certain styles, removing the Duchess title itself would likely require a political, legislative process. The essential point is this: any perceived legal right she might have is based on UK constitutional law, which gives ultimate authority to the Crown and Parliament. The idea that an American lawyer could successfully challenge the sovereign's constitutional authority in a UK court over a title granted by the sovereign is almost impossible to fathom. The battle would not be won on the merits of her public profile, but on centuries of constitutional law. The core political question: why the double standard? Beyond the legal gymnastics, the true firestorm is the political and ethical question now dominating UK commentary. If the monarchy has punished Andrew I, not the Sussex, the actions of Prince Andrew were undeniably damaging to the institution. But the relentless, highly publicised critiques of the monarchy and senior members of the royal family, published in a memoir, in a Netflix series, and in numerous interviews by the Sussexes, often involving allegations of racism or institutional neglect, are arguably treasonous to the institution's very fabric. The question here in London is not if the titles can be removed, but why haven't they been? Many believe King Charles is holding back to prevent a permanent, globally visible schism, perhaps betting that time and distance will render the titles commercially irrelevant. Conclusion: the inevitable outcome. So, we face an imminent showdown. On one side, a duchess determined to fight a perceived injustice, relying on legal advice that is, at best, optimistic. On the other, the future king, determined to slim down the monarchy and restore order. If Prince William decides to pursue the title removal, the odds are overwhelmingly on the side of the crown, utilising either the royal prerogative for the style, or a swift act of parliament for the peerage itself. The Duchess may believe she can win in court, but history and law strongly suggest she would only succeed in prolonging an already painful departure. Who do you think will yield first in this battle for the brand? Let me know your thoughts in the comments. Thank you, chums, and good to see you.